our last case of the morning, El-Jamaly versus Kirko Manix. Good morning. This is a 15-minute mini oral argument on the application. Both have 2 minutes of a free fire zone. And I believe we'll be splitting time for appellees. And you'll be keeping track of that, the split in your time?
Yes.
Okay, wonderful. Mr. Gonzato, you may begin when you're ready.
Mark Gonzato on behalf of the plaintiff appellant. With me at counsel table is Jeffrey Feldman, who is the trial lawyer in the case. The court has issued 2 questions to be answered in this case, 2 very different issues to defendants. I'm going to start, if it's okay, and by the way, I waive any self-imposed limitation on the asking of questions. I'm going to start, if I can, with the DTE issue in the case. The question with respect to DTE is obviously duty. The Court of Appeals relied on one component of the duty element in a negligence case, that is reasonable foreseeability. The Court of Appeals did not, in making that ruling, rely on the principal argument that DTE actually raised in the Court of Appeals. DTE did not stress reasonable foreseeability. Indeed, I think you can correctly read DTE's brief as eliminating reasonable foreseeability for a very good reason. And that is, there was no question with respect to reasonable foreseeability in this case. This is not a case with respect to the liability of an electric utility company, of a situation in which the utility company simply puts up lines, keeps them in the air, and sometime later there's a construction project that takes place, and there's an inadvertent contact with the lines. That is not this case. And the rather remarkable thing about the Court of Appeals decision, and I would suggest DTE's entire approach to this case, is that both the Court of Appeals decision and DTE have completely ignored the extensive involvement that DTE had in this case long before Mr. El-Jamaly was so badly injured. The fact is DTE did not just put up lines in this case. DTE was very much involved in the planning before the construction on this project even began. DTE, in fact, has what the trial court referred to as a concierge service, which they assign a team to certain users of their product, and they do whatever they can to accommodate that user.
So, counsel, I'm glad you're starting with this. This is definitely the part of the case that this part's hard for me. They use the concierge service here. What if they hadn't used the concierge service?
Well, this might then be a different case from a duty perspective, at least in the realm of reasonable foreseeability. But what happened in this case is the concierge service, the project manager, Mr. Fonteneve from DTE, actually met with the owner of this project 6 months before construction even began. Now, we don't know, perhaps from the trial record, what exactly transpired at that first meeting, but we do know that in March of 2017, Mr. Fonteneve was approached about taking steps to eliminate the danger that everybody knew existed. This was a situation in which Erlikon, the owner of the property, for their own reasons, placed the building as close as they could to these power lines. And by the way, these are incredibly powerful power lines, 40,000 volts. Okay, as I've indicated in my brief, the Schultz case was 4,800 volts. These are incredibly powerful power lines. DTE and Kirko, the construction manager, and the owner were all aware that these were a danger. And in March of 2017, we have the email train from Mr. Fontenay of DTE, in which he says you got to have covers over these lines during construction. That was something he wrote on March 22nd, 2017. They didn't. They did not. In fact, what happened in this case is there was a meeting.
Okay, so I understand that fact sequence. So let's assume DTE says you should have covers. And then the general contractor or the sub or whoever just says they just ignore the instructions. They don't do anything. So was DTE supposed to step in at that point?
Well, this is an issue of dispute in the record. But if you believe the Kirko people said we asked DTE to not just cover the lines, to de-energize them, to bury them, to raise them. That's the Kirko testimony. I acknowledge to you that it is undisputed, but for purposes of the case against DTE, what the Kirko people say is important, because what they said is take these mitigation steps, and DTE says, no, we can't do it. Now, what's very important in this case is that during the course of the case, DTE, there was a meeting in April. There was a person who was assigned to determine whether it was feasible to cover the lines. Okay, and that person, by the way, was Colleen Knight. Colleen Knight was asked after an in-person meeting on the property between Kirko, Orlikon, the owner, and DTE, representatives of all of them, what can we do to cover the lines? Ms. Knight says the following day in another email to the Kirko representative, nothing, we can't do it, it's not feasible. She misrepresented that. The fact is that it was doable. And in fact, the point was made about 11 months later by David Fontenay when he said, we'll quote you a price to cover the lines. So what happens in this case is we have a utility company which not only is very much involved in the planning stages of this, but it's asked to take mitigation steps. And what happens in this case is we not only have them not taking mitigation steps, we have them misrepresenting this. They misrepresented whether it could be done. That's what the record in this case shows. DTE misrepresented. They later raised the lines, and if you accept the testimony of Kirko, which is, again is disputed, but Kirko says we asked them to raise the lines at the beginning, and they said no, can't be done. Well, the following February, it was done, and by the way, it was done at a cost of $33,000, which Kirko and Orlikon paid. That's another issue in this case, because the suggestion has been made that imposing a duty in this case is somehow going to raise the cost of electric energy for consumers. The fact is that the defendants in this case were willing to pay for these mitigation efforts, and DTE still said no. So in terms of reasonable foreseeability in this case, this is a case in which the Court of Appeals got everything wrong. They started out with a subjective view of reasonable foreseeability. They said explicitly in their opinion, DTE couldn't anticipate this. That's wrong under this court's decisions. The most recent, of course, is Rowland. But even under a subjective test of foreseeability, this opinion is completely off the rails, because this is a situation in which it was not only foreseeable, it was foreseen. And it was foreseen by David Fontenay in the emails that he... Now, this case, I don't want to go too much longer on DTE because I only have a limited amount of time. But this is the testimony of, the deposition testimony of DTE's expert. His name is Dr. J. Prigmore. Dr. Prigmore was asked, is it foreseeable that a half-foot or 23.5-foot bolt could come into contact with these overhead power lines? This is the answer that he gave. He said, yes. In my experience, that's a reasonable concern. Companies would be aware of that and would try to mitigate whatever they could to prevent them from happening. That is DTE's own expert. And yet the Court of Appeals, ignoring all of the evidence of the involvement of DTE in this case, somehow comes to the conclusion that it's not reasonably foreseeable. This is completely incorrect.
Can we switch over to the first issue?
I'm sorry?
Can we switch over to the first issue because you only have 6 minutes left?
Pardon?
You only have
Common work
6
area.
minutes left. Can we go back? Can we go to the first issue?
Yes.
Okay.
Yes,
Thank you.
okay, let's talk, because this is a very important point, the Michigan law with respect to the common work area. The common work area doctrine, in my limited time that I have left, the common work area doctrine is something that has created confusion. It's been 20 years since Ormsby was decided. This court, I believe, I would suggest respectfully, has in fact issued decisions that cannot be harmonized. We know for a fact it is a 4-part test. That we know for sure. And the question, the major questions presented that can be answered in this case is, what are those 4 parts and how are they to be considered? The first part of it is in fact the part where I think there is the greatest disagreement in the decisions of this court. Gronke, as I've indicated, I think on one page of my brief, I think it's page 56 or something, I've put next to each other the Gronke version of the 4-part test and the Ormsby version. The Gronke thing just says in the first part that all you need is a general contractor with supervisory or coordinating authority. That's all you need. That we have. The Ormsby test introduces something that became very important to the Court of Appeals in this case, and that is the general contractor failed to take reasonable steps within its supervisory authority. Very different slant on things. But the Court of Appeals went one step farther. The Court of Appeals said that we couldn't satisfy that first part of the test because Kirco did something. Kirco actually did something. I agree. Kirco did something. They pleaded with DTE to do something to mitigate these things. What the Court of Appeals did in this case is to say that just because they did something, we could not satisfy this first prong. Now, the first thing this court's going to have to address, is it Gronke that controls, or is it in fact Ormsby on this first part? Let me move on from that, because...
Well, before you do, can I just ask you, so I understand you say that the defendant and perhaps the Court of Appeals adopted it of saying, as long as we've done something, therefore we're good. I will admit I'm troubled by your position that says as long as there's something else out there,
No,
then they didn't.
No,
So
but
like those seem like two extremes. What is, and you're telling me that that's not your position. You're saying if there were things left on the table that they could have done, then they haven't satisfied that first
Yes,
prong.
and what I would suggest to you is even under the Ormsby test, I am correct. Because what the Ormsby test says, the general contractor failed to take reasonable steps. It doesn't say they took some other steps that were reasonable. They failed to take reasonable steps to combat a known danger. Okay, and we have that in this case. In fact, MIOSHA investigated this case, and as you probably know, MIOSHA usually investigates the employers, just the employers of a person who is injured. In this particular case, MIOSHA investigated Kirco because they had overall control, and MIOSHA assessed penalties against Kirco for failing to do a couple of things. One of them, the sign that got blown over. But the fact is that this is not like a negligence case. I understand your reference to that. But what even if you accept the Ormsby test, all it needs is that the general contractor failed to take reasonable steps. The fact is we proved that they failed to take reasonable steps, these other things that they didn't do, including, by the way, watching. There was a Kirco representative watching this pour. He watches a pour that takes place under these 40,000 volt wires, and he sees these men with long-handled tools, and he sees that they are not, he knows, at least from past experience, they are not the appropriate ones to be used under this. They're not fiberglass.
So can I, before we run out of time, I want to bring, my sometimes frustration with these cases is that how you define the hazard
Yes.
dictates sort of the answer to the other factors.
Yes, I was.
And the Court of Appeals says that your position was that the hazard is the mere presence of overhead lines at the construction
Yes,
site.
that was our position. And because the overhead wires, as you can understand, were present during the entire course of the construction. Now, the Court of Appeals disagreed with that, but I'm willing to accept what the Court of Appeals held.
That was my
because
question.
what the Court of Appeals held instead is, thus the pertinent danger, I'm reading for their opinion on page 14, the pertinent danger for purposes of the common work area is not not the power line itself, but the risk of electrocution from the use near the power line of high-reaching conductive tools or equipment capable of reaching the lines. I accept that, okay? The fact is, that's the danger here, the use of high-reaching tools. Now, I've got very
Tools or
little...
equipment, so your contention is you're fine with that rule, and the Court of Appeals goes astray in then how they apply the other factors relative to that risk, because it's not just, I mean, the next paragraph, the Court of Appeals says, you know, the rule is conductive tools or equipment capable of reaching the power lines, and then they evaluate the significant number of workers and the common work area issue from both floats specifically.
What I've suggested in the brief is that the Court of Appeals failed to apply its own test.
Okay.
That's what happened in this case. Now, the third and fourth issues, or the third and fourth factors, are very, very important here. And it's an issue, these are two issues that this court has to address, it seems to me. Because what has happened, if I can take a little bit more of my time, what has happened in this area is the third and fourth factors have to do with whether the common area existed and whether multiple people were subject to the danger involved. There is a huge question in this case because the defendant's position is you take a snapshot, you look at the time that this occurred, and you check to see if there are multiple people on the job and multiple different trades on the job at the exact point and at the exact time that this occurred. The fact is that is incorrect. I don't have much time, but the fact is that is contrary to what this court found in Funk, because Funk talked about a much longer period of time. It is contrary to what this court said in Gronke, because Gronke said that it's just whether multiple trades will work on the job eventually. But about the best you can see, it seems to me, in this area happens to be the Sixth Circuit's opinion in Richter, which has a very good analysis under the common work area doctrine about how long the danger existed. And what's important about this case, that even if you take the Court of Appeals determination of what the danger was, inadvertent contact with a tool during the course of construction, that is a danger that existed throughout construction in this case, and any place that was near this building. I have a lot of time. I'm sorry. Thank you.
Good morning, Your Honors. Lincoln Herware on behalf of Defendant Appellee DTE Electric Company. Obviously, I take issue with a lot of what Mr. Granzato said, especially since he's brought me off my script. I need to address Dwayne Allison was the Kirko Construction manager. When he was asked whether they had ever offered to or tried to get DTE to bury or relocate these lines, he said he never even broached the subject. I'm listening to Mr. Granzato saying that Kirko begged us to do something. When asked if he would have been willing to have us cover the lines, he said he would have paid up to what he thought was $50,000. The fact that the lines could have been covered at particular sites, small sections, on a very temporary basis, does not mean that these lines, it was feasible to cover these lines in such a way that it would have prevented Mr. El-Jamaly's injury. There was 453 feet, approximately, if my memory serves. There's 6 lines, because there's 2 sets of 3. They would have been about 1,700 pounds per line to put this stuff on. And where Mr. El-Jamaly was working was not a place that would have been the focus of the perceived peril of these lines with regard to the building. I just heard Mr. Granzato said anywhere near this building. Where he was injured was not near the building. He was between the fire hydrant and the curb line. The fire hydrant was 6.7 feet from the curb line. That fire hydrant was there was another 14 feet to the electrical boxes that we had installed for underground service to the Orlicon building. There was another 18-some feet to that first pole that terminated the span on which Mr. El-Jamaly was injured. And then the next span that went another 150 feet north was the one that was near the building, which would have been the focus of where the peril was. The issue of duty, Mr. Gonzalo thinks that we didn't focus on the issue of duty. That was the complete focus on all of our briefing. But we had all these Supreme Court cases that already had determined that this type of conduct, this type of act is something that's not reasonably foreseeable to an electric utility. So of course, we're going to rely on Michigan Supreme Court precedent after precedent after precedent. And we're going to say, here it is. This is not the type of thing that's foreseeable to us. And when a court says that something is not legally foreseeable as a matter of law, as they tend to do, they say, you had no duty to anticipate this. This party had no duty to anticipate. That's the language we use, and that's not language that we made up. That's the language of this court. It's the language of the Court of Appeals in case after case after case. We don't have to anticipate it because it's not legally foreseeable to us. It's not legally foreseeable to us because it's not the kind of thing you can say, I know where it's going to happen, I know when it's going to happen, I know how it's going to happen. We can be there. How can we de-energize this line to protect Mr. El-Jamaly if we don't know when he's going to touch that line? Yes, we de-energized these lines while we were installing the inbound electricity to those boxes. And there's another set of lines. It's a redundant system to keep the lights on for thousands of downstream customers. In our society, electricity is an absolute necessity for our cultural, social, physical well-being, the health of people. We can't live without electricity. I stopped being a lawyer when the power goes out. I don't know how to do it. There are people who literally, I've had cases, the power went out and something very terrible happened to them and then they sued us because the power went out. Keeping the lights on in our society is an utmost priority. And we can't just say, well, from March until November, we're just going to shut off the power to all those people because someone might do something that we can't even predict. You know how we know this was not reasonably legally foreseeable to DTE? Because no one foresaw it. And no one foresaw it, no one prevented it, and after the fact, no one can even explain it. To this day, no one has offered an explanation of why Mr. El-Jamaly or anyone else on the Merlot crew would have needed to lift a 24-foot metal pole up into those power lines. They weren't working in the air. This is flat work. It wasn't the type of bull float from the days when I used to do concrete work where you had a set angle on it, and on the backstroke you had to lift it up. This was the kind that had that joint at the bull float itself, where all you had to do was turn that handle, and the bull float with the front end on the backstroke would be forward, and you turn it the other way, and the back end on the upstroke would be down, and they never had to lift this up. They could have disconnected with the push of a button. This was never unreasonably dangerous to Mr. El-Jamaly. It was never unreasonably dangerous to anyone on that Merlot crew.
Are you splitting the time?
Yes. Am I out of time?
You're into his time.
Okay. Very good. Thank you, Your Honors.
But it's very good, though. I like your
No,
passion.
it's not. No.
You have a little more.
You have a little bit more time.
Was it 10 minutes apiece?
No, 7 and a
Oh, I'm
half.
sorry. You got another 2.5 minutes. I'm so
Go
bad.
for it.
Come on back.
Well, I put away my stuff. I'm going to
Now
have
I'm going to have to ask you a question to make it 3.5 minutes.
if there are any questions, that would probably be the best use of my time.
Would DTE have owed a duty if it would have been under the 18 feet 7 inches required by law?
Yes. In fact, I should get into that. When the accident in 1983 happened, it was, Schultz was a 1992 or 93 case, but the accident was 1983. And at that time, the NESC simply provided guidance on what the industry standard was in order to make an overhead power line reasonably safe. But since then, the MPSC enacted Rule 460.813, Rule 813, and they expressly incorporated into Michigan regulations the NESC. And under the Rule 232 of the NESC, the required clearance on a line like this would have been 18 feet 7 inches. If that was below 18 feet 7 inches, it wouldn't be that we had violated the NASC, we would be in violation of the Michigan Public Service Commission regulation. Now, this was 30% higher. DTE went substantially over and above what is recognized by the positive law to be a reasonable standard for this line. And, you know, at some point, this is a peril that we have to live with.
But isn't isn't it true, we know that breach of a regulation isn't evident, it may be evidence for it, but it doesn't establish negligence. Does compliance with the regulation establish that there wasn't negligence?
I would say compliance with the regulation establishes a prima facie case for saying you did what you were required to do. These are the kind of...
Why, though? Because the opposite doesn't work, right? Like every defense attorney, I'm sure you've argued this, if you breached the regulation, that isn't a rebuttable presumption that you've committed negligence.
It's actually a presumption of negligence, but it's rebuttable. We would have to come forward with powerful evidence why
It's
we're
evidence
excused.
of negligence.
Yes.
Not a not
It's not irrebuttable.
presumption.
It's not irrebuttable. And
Right.
so, I'm not here to say it's irrebuttable proof that we were not negligent, but the point is the industry and our society has agreed there's a certain level, a certain height, you're gonna put these lines to make them reasonably safe. We were way over and above that. And at that point, you would say, well, how are we to foresee that someone is going to bring this tool into contact with it? This would be like, picture a train going across the road. The lights start dinging,
But Counsel, I have a
the gates
question.
come down.
Oh, Counsel, I
Now,
have
what
a
if someone
question.
drives around? I'm sorry.
No problem. I have a question, though. First off,
Certainly.
I love your passion. It's
Well,
fabulous. I guess the question is, and I totally hear your arguments and totally can appreciate what you're saying, but the question is that the company was put on notice that there was construction that was being done, correct? They
Yes.
knew about what was being done. The company was aware that, there was some modifications that were being requested, like to cover the lines, right? And those modifications were rejected, correct?
No, that's not actually correct. Our people on site, Dave Fontenay, Colleen Knight, they're salespeople.
Right.
They're there as the face people, like the customer service representative that's going to help them
Okay.
get electricity. And Dave
But
Fontenay said,
but very quickly, they were aware, and I hear your argument, I totally understand it, but they were aware that there were people that were working kind of close to these power lines. They were aware that the building was located very close to the power lines. They were aware that it was an active construction site where you had people in constant movement because it was a relatively sizable project. And, they were aware that people were in close proximity of these lines, correct?
they were aware that periodically, in order to get to the building, there were vehicles moving from a laydown yard that was on the east, under these lines, to get to the building.
And now, really quickly, go to the modifications. My understanding, and I just want to make sure that our understandings are both correct. I was under the impression that there was a request that was made for a covering.
The suggestion was made by Dave Fontenay that he's going to look into coverage. Colleen Knight said it cannot be done. She didn't do all the emphatic things that Mr. Grimzato said she said. She said it cannot be done. And that's a correct answer, because in order to provide blanket protection, if we don't know where and when someone's going to do this, in order to provide blanket protection over all these lines, that was not feasible. But the real key, when you're thinking about, okay, they were aware there was this risk.
I don't want to harp on this, though. These were not your ordinary lines. These had, as we heard from Brother Counsel, they have like 40,000 volts. I mean, these are pretty intense lines, right? They're not your standard.
They are, but from someone who's familiar with electricity, it only takes 50 to 100 milliamps of current to kill someone.
I see. Okay.
This is sort of like if you say, oh, I dropped out of an airplane at a half mile up.
I see.
Versus 10 miles up. It's pretty much the result is the same once you get to a certain.
Thank you very
DTE
much.
oh, sorry.
We
Okay.
need to hear from Mr. Halbach. Mr. Halbach, the clock says 3 minutes and 40 seconds, but you can have 7.5 minutes since since we
Thank
kind
you, Your
of
Honor.
messed with the time a little bit, so.
I appreciate Your Honor. Thank you. Good afternoon, I believe. Your Honors, David Hobeck, appearing on behalf of Kirko Manix Construction, LLC, one of the defendant appellees. Counsel for Orlikon did also request, Your Honor, 30 seconds or a minute just to address some of the things that Mr. Gonzato.
That'll come out of your time, so.
Okay, all right. Thank you, Your Honor. That's why I wanted to mention it at the beginning. And so the question, as it relates to Kirko Manix that this court posed, was whether the Court of Appeals erred in holding that Kirko Manix Construction, LLC, cannot be held liable under the common work area doctrine. And my argument here today can be very brief, based on the admission that Mr. Gonzato made to the court this afternoon or this morning, which is the plaintiff is willing to accept now, despite the fact that they weren't in their briefing, that the danger at issue is limited to contact with the overhead wires that causes an electrical injury. And why the argument can be brief is because this is one of those cases where there's no evidence of any other subcontractor working on this construction site that had tools or equipment that were both long enough to reach these overhead power lines, number one, and number two, that were made of conductive material. And why that's important is because the plaintiff's electrical engineering expert testified.
Because I have a quick question, and you're doing a great job too, but the question I have is, there was a sign that was posted, correct, about this? That there was concern enough that a sign was posted on the site warning folks, right?
Correct.
And that sign kind of, there's some question as to whether that sign kind of blew down and was not replaced, right?
So one sign, there was a redundancy of signage, and we've attached it to our briefing package. There were dozens of signs related, warning of the presence of the overhead wires on the construction site.
Okay, very good.
Yes.
What about the crane?
So
And just to sort of say that, so Mr. Gonzato is saying that taking the Court of Appeals, saying the pertinent danger is not the power line itself, but the risk of electrocution from use near the power line of high-reaching conductive tools or equipment capable of reaching the power lines, and then goes on to look at common work area and sufficient number of workers or significant number of workers by saying who else was using bull floats. Their own task says tools or equipment, and there was a crane a couple months prior, I understand in a different location than where the plaintiff was in particular, that was equipment that was capable of reaching the power lines and in fact severed the power lines. Why are we only looking at bull floats and somebody using a bull float?
Yes, Your Honor, and the admission of plaintiff's counsel is what is so important about that, because the identifying the danger that's at issue comes from Latham 1 and Alderman, which said in those cases, Latham involved a fall, and this case is similar to a fall, where they said the risk is not falling from heights. The risk is falling from heights without fall protection. Because if there's fall protection, if the subcontractor provides its employee, as they should, as is the subcontractor's duty, with safety equipment, then when the employee falls from height with fall protection, there's no injury. So the danger isn't falling from heights. The danger is falling from heights without fall protection. Identically here, where the danger is not contact with the overhead wires, which is all that happened in that first incident that Your Honor's indicating. There was no electrical injury. There was no injury whatsoever. There was no electrocution. There was nothing. Why? Because that subcontractor was using the appropriate non-conductive protective equipment. And so that's why it's completely different and distinguishable from what we now know the danger is, which is contact with the wires and risk of electrocution. And the plaintiff's experts testified that if this plaintiff was using a non-conductive bull float made of non-conductive material, there would have been no injury whatsoever. And that's exactly what happened in that first incident. And that's why this is not a common work area, because the only evidence in the entire record of any subcontractor using tools or equipment, Your Honor, of both length to get to these 24-foot high lines and that was made of conductive material is Merlo, is the plaintiff's employer. And the testimony, the record evidence is that there were only 2 bull floats on site. So what we know is at most 2 employees of a subcontractor were exposed to this risk. And the Alderman case from 2010 This court identified that 2 to 6 employees of one subcontractor is not enough to carry the burden to establish that a significant number of workmen were exposed to the same risk. And so the fall cases and the electrocution cases are very analogous, because I think it's very persuasive to say, well, look, when you're working at heights, everyone working at heights could fall off that building and get injured, right? And this court has said in Latham 1, no, that's not the danger. The danger is not falling from heights. The danger is falling from heights without the fall protection equipment. And here, the danger is working with conductive tools, working with tools long enough to reach these wires that is made of conductive material, meaning not having the proper equipment provided by the employer,
Let's hear from Mr. Garish now.
Yes.
Okay, thank you.
Thank you, Your Honor. So, thank you.
I appreciate it. Thank you, Your Honor. Jeffrey Garish on behalf of Orla Khan. Because the court's questions were not directed at Orla Khan, I had not planned to present any argument, but Mr. Granzato twice said that Orla Khan was the property owner. It was not. It was not the property owner. It was to be a future tenant and that didn't have any possessory interest until April of 2018 when the certificate of temporary occupancy was issued. Thank you for your time.
So I'm just confused. You guys were a renter, and you were going to take ownership at a certain, you were a rental?
The building was being built for Orla Khan,
Right.
but it did not become a tenant until 5 months after the accident. It had no possessory or ownership interest before
Thank you.
then.
Okay, great, thank you all. The case will be submitted, and we will stand at recess until 1 p.m.
Right.